House Prosecution Panel is seeking a reconsideration of the Supreme Court's ruling that voided the impeachment articles against Vice President Sara Duterte. To discuss that, we are joined by House Prosecution Panel spokesperson Atty. Antonio Bucoy. Magandang umaga po sa inyo.
Magandang umaga rin sa iyo at sa lahat ng mga nanonood.
So you are still officially prosecution spokesperson?
Yes. Nothing has changed.
Okay. Just the turn of things.
Just the turn of events, yes.
Okay, which is better for the prosecution? Is it the archiving or the tabling? Which would you have preferred?
It would have been the tabling. Because should the Supreme Court grant us relief, all that the Senate has to do, or the Senate has to do is to reconvene as impeachment court. However, with the archiving, the court, the Senate has had introduced a new innovation, archiving, which means before the trial would resume, they would have to, someone would have to make a motion to revive the articles from the archive, and they would have to vote.
So it requires another step.
2 steps.
Ah.
2 steps.
Ang sabi naman po ni retired Justice Ascuna ay pag naka-table ay maaaring ma-dismiss. Pero pag archive, pwedeng mabuhay ulit.
Hindi po. Yan ang pananaw ni...
Yan ang pananaw niya.
Opo. Iba ho yung, magkaiba yung aming anggulong tinitingnan eh. Magkaiba po.
Okay, you filed a motion for reconsideration before the Supreme Court. May I know what is in there? What are you asking them to reconsider exactly? It's been discussed that there could have been errors in facts. What is included in the MR?
How much time do you have for me to
enough
explain?
Time to break this down for our audiences in a way that people could understand.
I'll encapsulate the arguments. The decision said, first, that the House of Representatives neglected and willfully took in action. They did not take action on the first 3 impeachment complaints. That's wrong, because the House took action by including the 3 complaints all together at the same time to plenary within the 10 session day period required by the Constitution. Second, the decision faulted the House Representatives for entertaining the 4th impeachment complaint, considering that it has violated the 1-year bar rule by reason of the inaction and archiving of the first 3 impeachment complaints, which the Supreme Court considered as dismissal, okay, and therefore considered as the initial action. So mali din po yun. Third, that the Vice President was deprived of her right to due process. Fourth, the court introduced innovations that were not in the Constitution by providing guidelines on how future impeachments under the second mode, which is endorsement by 1/3 of the members of the House. They introduced 7 requirements which were never been heard, which have been unheard of and not in the Constitution. And then finally, they applied their ruling, this new doctrine, which overturned Francisco and Gutierrez, these 2 cases, retroactively, not prospectively.
So yun po yung mga arguments natin.
Yes, well,
But-
7 points.
But did the House go to a plenary vote
Yes,
before it transmitted the articles to the Senate?
yes. In fact, when these were all referred to plenary, after it was included in the order of business within the 10 session day requirement, the House Journal itself and the congressional records will show that all 4 impeachment complaints were referred to plenary. After reading the first 3, then they read the 4th. Inasmuch as the 4th complaint was by virtue of the second mode, which is the self-executory mode, in as much as it had already garnered at least a third. Ito nga, 215 eh.
Ito pong mga signature sa plenary po yan nakuha.
The signatures were given, were secured prior to the filing of the complaint. Hindi sa plenary.
Okay.
So, that was according to the Constitution, if you already have one-third at least, it's self-executory. The Constitution says, this complaint shall constitute the articles of impeachment itself. With that event, the one-year period had been triggered. In fact, the Constitution does not require plenary to vote, to approve, if it's via the second mode of impeachment. But the House took an extra step, took an extra effort by voting to approve upon motion by the majority leader. So, sumobra pa, labis-labis pa yung pag-iingat na ginawa ng Kamara. Having transmitted the articles of impeachment, which was initiated by the second mode, when they went into upon suspension of session and then when they resumed, the majority leader again made a motion to archive the first three complaints because there was nothing left for Congress to do. The one-year bar rule had already been triggered by the second mode, which was transmitted to the Senate. So, baliktad ho yung naging findings ng Supreme
Pero nagkaroon
Court.
po ba ng affidavit? Nakapirma po ba yung mga congressmen?
Oh,
Kasi
yes.
parang nandun sa House rules po yun,
Yes.
na kailangan nilang pumirma.
They signed and they verified it. In
That
fact,
they read the articles
Yes.
of impeachment,
Correct.
and that they know what they
yes,
were
they
signing.
have read it, they caused the preparation.
Meron po kayong kopya na.
Yes, in fact, that's attached to the articles. In fact, what the House did was copy verbatim the required verification in the House Rules of Impeachment. Hindi lang yung sa Rules of Court. Mas exacting yung ginawang verification ng 215
Correct.
that they have read, signed, and verified. Mas exacting ho yung kanilang verification. Ang sinunod nila, verbatim, yung form sa Rules of Impeachment ng House. Hindi lang yung the ordinary acknowledgement under the Rules of Court.
Pero ang question din po kasi ng iilan, ano po nangyari doon sa first three? Bakit po naupuan ito?
Hindi ito inupuan. Under the Francisco and Gutierrez doctrines, there is no preference under the Constitution or priority in terms of mode of filing. It can be the first mode, which is the complaint by a congressman or a complaint by a citizen endorsed by a congressman, or the second mode, which is at least one-third. The Constitution doesn't say na we prefer this mode as against the other mode. There is no preference also as to the time of filing. As long as the one-year bar rule, and as long as the one-year bar has not been triggered yet. So, under the Gutierrez doctrine, the House can refer to plenary all impeachment complaints. Hindi ito first to file eh. They can refer, there can be multiple complaints, the multiple complaints individually can proceed independently as long as there is no initiation yet. So pwede ho yan sabay-sabay i-refer, which is what the House did. Which is what the House did. So, hindi pinabayaan.
But how about the argument or the debate over the 10 session days, the 10th or the 11th?
No, the 10 session day period, like I said, pasok ho dyan. All four. They were
Help
all...
us understand bakit pumasok. Kasi yung iba nga po ang sinabi, 11th na.
Ganito, no? Yung December 2, yung pinakaunang complaint eh. That was the very first. Ang session days sa Senado, hindi calendar days. Okay? Ang one session day can mean 1 day, 2 days, 3 days, or 1 week. Depending on when they convene and when they adjourn. When they adjourn, that's the end of one session day. So siguro sila nagtataka, December 2 pa yan. Ni-refer February 5. That's more than 10 days. Hindi calendar days yan. It's session days. So, pasok lahat yan because there's a December 2 complaint, yung una, there's a December 3, and then there's the December 9, plus the February 5. They were all referred, included in the order of business within that 10 session day period.
Ibig sabihin, kailangan working day ito.
No. It's session day.
Session.
May sarili hong session calendar ang Kongreso eh. Na gaya nabanggit ko, it can be 1 day, 2 days, or 1 week.
So the 2/3 or 1/3 vote was passed on the 10th session day.
The 1/3 vote endorsement by the congressmen was garnered even before it was filed. Kailangan may at least 1/3 na eh.
But it was filed on the
10th.
10th
within the
session
10th
day. That's
session
the
day.
argument of
Yes.
the prosecution.
That's not the argument, that's the fact.
Okay.
And that's supported by the congressional records.
Were you given sufficient space by the Supreme Court to hear this, to be able to dissect all of these facts?
These
ano
were
pong
all-
hinihingi po sa inyo ng Korte Suprema bago po sila nagdesisyon?
With respect to the first petition, we were able to file a comment. Okay? If you will recall, a subsequent petition, a supplemental petition, was initiated or filed by the Davao lawyers. We were not given the chance to comment on the second petition. On the supplemental petition, what the court did was, the court issued an order requiring the House to answer specific questions. So the House addressed only those questions.
And were those questions centering around these facts?
Yes. These were all dealt with or addressed, including that House journal, which was submitted to the court to prove that the complaints were acted upon timely, seasonably, within the 10 session day period. However, when the decision came out, it's as if the court did not read or consider what was in those records. This was filed in the compliance. This was included in the compliance. But this was not addressed by the court. On the contrary, the court said there was a violation because it was not taken up at plenary, meaning the fourth impeachment complaint, before it was transmitted to the Senate. It was. It was taken up in plenary.
Okay,
And there was a
So
vote.
what do you think would make this motion for reconsideration convincing if you're presenting the same facts?
We have presented the same facts, but we're raising them anew because there is a necessity for the prosecution to call the attention of the court or remind the court that these are in the record. These arguments had been laid down. So we just had to expound anew and to remind the court that with due respect, please revisit the decision. If you will now note, there are now 5 pending motions for reconsideration.
Tama ho.
The first and primary was the one filed by the House. And then the 3 others were filed by the proponents of the first 3 impeachment complaints. Even they agree with the position of the House. And finally, a petition for a motion for intervention and to admit the motion for reconsideration was instituted by Sambayan, spearheaded by former Senior Associate Justice Carpio and Associate Justice Conchita Carpio Morales, who penned, she was the ponente of the Gutierrez case. Yung doktrina doon, ang ponente, si Justice Carpio Morales. Ang masama pa ho dito, if I may revisit what I previously said, instead of applying this doctrine prospectively, the court said, no, retroactive to. But the doctrine prevailing at the time all these acts,
Mr. Francisco,
acts were
versus HR.
performed, the doctrine prevailing were the Francisco and
the
Gutierrez
Gutierrez.
doctrines. How can the House comply with a doctrine that had not yet existed? So, effectively, the House was penalized for following the law and following the doctrine laid out by the Supreme Court, by the same Supreme Court prevailing at the time.
Which is the doctrine of operative facts.
That is, yes, doctrine of operative fact, meaning if there is an overturning of doctrine, if there's an amendment to the law, you apply it prospectively, not retroactively. So, pinagalitan kami, ang House was faulted by the court for not obeying a doctrine that had not existed.
Tingin niyo ho ba mahihirapan na ma-overturn itong ruling ng Supreme Court? Si Senator Marcoleta na po nagsabi, medyo imposible yata yung
Dahil 13-0.
pag unanimous ang boto ng Supreme Court, magbabaliktad sila, papalitan nila
The Supreme Court, there are precedents in this. There were previous cases wherein the Supreme Court voted unanimously also on a certain decision, on a doctrine. And they reconsidered and reversed themselves. Nangyari na ho yan. This would not be the first time. And like you mentioned, the arguments in the motion for reconsideration filed by the House, as well as the arguments raised by the 4 other motions for reconsideration in intervention, are all compelling. So, again, we earnestly hope that the Supreme Court will take a second look. Will take a second look, rather than just leave this decision as it is, without correcting it. This sets a terrible precedent.
If this motion for consideration is not granted, you will refile, the House will refile
Yes,
again
we will.
this coming February 6th.
Yes, I think, yes, we will.
And given the new requirements set by the Supreme Court in initiating an impeachment complaint,
Yes.
and all that come with it, how are you planning to do this differently? Unahan na ba yan?
We plan to do it carefully, more carefully. And under the existing doctrine, existing decision, not doctrine, as if unreversed, in street language, unahan sa draw.
Unahan po yun.
Unahan sa draw yan. But which the Constitution never...
Required anyway, in the first
the
place,
Constitution
na may unahan.
did not. There is no such concept in the Constitution. Like I said, there is no preference. Ang sinasabi ng saligang batas, there are 2 modes. Okay? The first mode, which I mentioned, na may referral to the Committee on Justice, and the second mode, yung at least a third, na self-executory, automatic articles na yan. Hindi sinabi na kung sino maunang mag-file, unang complaint na i-file, yan na yun. There is no preference of mode, there is no preference of timing. But as it stands now, if unreversed, unahan sa filing. No matter how capricious, no matter how baseless, no matter how unsubstantial yung complaint, all that the impeachable officer would have to do is have someone file a baseless complaint, have it referred to the committee, and then, triggered na yung 1 year. Triggered na.
Okay, but this time around, kasama po dun sa mga requirements ay yung pagpipresenta ng ebidensya. Napapabasa nyo na po sa lahat. At you're gonna give the accused sufficient time or a chance to be heard and the supporting evidence to prove the charges prior to transmittal to the Senate. How difficult would that be?
It's not just those, no? First, among the 7 guidelines, first, that there must be a detailed, convincing evidence in support of the complaint.
So dapat nakalapag na lahat?
Yes. Number 2, the impeached officer must be provided with the articles and with these pieces of evidence. Number 3, she must be allowed to respond. Second mode ito, we're talking of the second mode, not the first mode. 4th, all members of Congress, not just the 1/3 who endorsed the impeachment complaint, should be provided with the articles and with all attaching...
The pieces of evidence?
Yes, all pieces of evidence. Number 5, they must execute a sworn statement, an affidavit, saying that they have read and they have
So pag hindi po
understood.
napirmahan yun, pwede rin pong mastall itong mga impeachment, yung pag-refer to the Senate.
Yeah. But let me finish the 7.
Okay, go ahead.
Number 6, there should be a deliberation by the plenary. And they must vote in favor of the articles of impeachment. Bakit ho ito mali? May 1/3 na na nag-endorse. Why do we have to vote again and get the 1/3? May 1/3 na. What is the danger here? An influential, impeached officer would be given an opportunity to overturn the 1/3 by legal or extra-legal means. Okay? It can subvert the process. And finally, yung 7th, the hearing in the plenary must be attended by the impeached official.
So pag hindi rin po siya nag-attend, pwede rin po hindi
She can waive.
makumpleto itong
She can waive.
pitong requirements na
She can
ito.
waive. She can waive naman. Although hindi sinabi yan, but it's implied. So 7 that are nearly impossible. Wala ka nang mai-impeach via the second mode, which is supposed to be self-executory. Via the second mode, it's nearly impossible to impeach any impeachable impeachable
Is it
official.
possible that the Supreme Court will realize the transcendental impact of this decision
That's
on
what we hope.
future impeachment complaints?
Yes, that's what we hope. If we will recall, again, I would like to stress, it is not just the House now which has sought a reconsideration. A lot of other groups have filed independent motions.
What do you think about the suggestion of retired Justice Ascuna saying that they can somehow manage the impact of this decision by filing a supplemental resolution saying that this case, the ruling is for this case only?
That is acceptable. That is one way of curing.
Given that because of the unusual
Yes.
circumstances surrounding.
But that's only part of curing the decision, which I said were based on erroneous premises and misapplication of law and jurisprudence. That's only one. More importantly, is to fix the portions of the decision which we perceive as intrusion into the prerogatives of the House, intrusion into the authority of the House as initiator of impeachment proceedings. Dapat to ma-address din yun Hindi lang yung prospectivity, but the more basic would be to address the questions of diminishment of the powers of Congress as initiator. Mas mahalaga. And what is perceived as judicial amendment of the Constitution. Why amendment? Wala hulat to sa saligang batas.
Do you think there are enough safeguards against the other argument that the impeachment complaint was mostly about politicking, which was put on record by many senators that the charges versus the Vice President are politically motivated?
Listen, impeachment is a mechanism in the Constitution to enforce accountability. It is not for politicking. This is not about 2028. This is not about a single person, the Vice President. This applies to everyone, all impeachable officers. The problem is, the current situation favors an individual, regardless of at the expense of the people, the body politic. The current situation shields an individual, not the body politic. If there is a balancing of interest between an individual's rights and the rights of the public, the body politic, the scale of balance should be tilted in favor of the body politic. Dapat ang sambayanan.
And given that situation, how confident are you that if you refile on February 6th, that you'd get enough votes to have this go through?
We just have to deal with the situation. We just have to face it. Simply because it seems insurmountable, we'll just give up. We are for accountability.
Alam ko po if you take a look at the Constitution, the Vice President, it's not stated explicitly that she is immune from suit, but parang if you take a look at practice, medyo it's not done. But is it possible to go that route? To have accountability?
That's one recourse. But that's why there's a mechanism of impeachment. It is an immediate relief. It should provide an immediate relief to society. Okay? The Vice President is not among those with immunity from suit in the executive. It is just the President.
So pwede po siya makasuhan?
That's one route. Okay, but that takes
because I remember you being very confident with the pieces of evidence that you have. At ito yung ayaw makita.
Ang impeachment is for accountability. That recourse through the regular courts, that is to enforce liability, penal liability. Okay, yung criminal cases may be filed, against the Vice President, etc. That's another avenue. But that is not an instant, immediate.
Medyo matagal.
Kaya nga ang impeachment process,
baka wala na po sa posisyon ng
moot and
vice.
academic na. Kahit na maging moot, there's still criminal and liability. Okay?
Kung manalo po siya sa 2028, naging immune pa rin po siya, no?
Magiging siyang immune kung maging presidente siya. Magiging immune. Ngayon, wala siyang immunity.
What would you have to say to the Senate President saying there is a move to unseat him, given ito pong lumabas sa Rappler na isa pala sa mga main contractors of the government, Centerways Corporation, is the owner is his primary donor, the biggest donor in his campaign. What would you have to say to that?
Hindi nasaklaw ng aking mandate yan. I'm for the impeachment. Kung ano man yung politics that goes on, the politics involved that's going on in the Senate, that's beyond me. I would rather not comment. Ako, impeachment lang. Ayoko nang panghimasukan pa yon.
But could you comment on the hearings on the Senate floor and the debate that went on amongst the senators? What was going on in your mind while you were watching?
They got it wrong. I mean, the proponents got it wrong. Completely. Mabuti pa yung tatlong hindi abogado who stood up and spoke on behalf of the people. Senators Ping Lacson, Tito Soto, and Rizal Tiberos. They absolutely got it. And they were citing authority. They were citing factual records. They were citing jurisprudence. I'll leave it at that.
And with that, we shall await the decision of the Supreme Court with the House's motion for consideration. And if not, the February 6th refiling of the impeachment. It does make the process more interesting. Before we even get to any trial, it's theater in itself, right? Thank you very much for joining us this morning and explaining, breaking things down for us. We hope you understood all the facts that matter and the context surrounding the facts. We have House Prosecution Panel spokesperson, Attorney Antonio Bucoy.
Always a pleasure.